Welcome back. A live look here in New York City, where news broke just over an hour ago. An appeals court has declined to hear former President Trump's challenge to the gag order in his criminal case involving alleged payments to adult film star Stormy Daniels.
At New York's highest court, they're leaving that gag order in place ahead of Trump's sentencing. It is scheduled for July. We'll bring in Shondell Summer, former Fulton County public defender. We have Aaron Reed, a criminal defense attorney. Doug Burns is back, former federal prosecutor. Thank you all for returning. We appreciate that. Ms. Summer, if we can start with you on this one. The appeals court judge ruling that the appeal was dismissed upon the ground that no substantial constitutional question is directly involved. Again, not taking this one up. You can see that on your screen. Again, this gag order is still in place for Trump. There's this argument about whether his constitutional rights were violated. What does this exactly mean, Ms. Summer?
It means that the appeals court found that the trial court properly issued the gag order and that there was no constitutional violation. Had they found that the court improperly issued the gag order, they would have taken it up on appeal. But it seems to me that since the case has been completed, there's been a conviction, there's really no need for a gag order at this point. However, the court found that the need was justified by the fact that witnesses would be intimidated by statements made by former President Trump.
Aaron, we'll go to you. You know, this is obviously not just an American citizen here we're talking about who has a gag order placed on him in a criminal case. This is a man who's the presumptive Republican nominee for president who's actively campaigning. Perhaps he would be mentioning the criminal conviction that he is facing here, or the fact that he wanted to comment on the how he would view the legitimacy or lack thereof of this case. Should he be allowed to speak about it? How do you think this plays into even First Amendment rights?
Well, thank you for having me on. I agree with Ms. Summer. I think that there is a weird dichotomy here. I think he is being treated a little different than a normal person, albeit I don't think many people are going to have gag orders in their case. Most of the time, judges just tell you not to talk about it, and people just listen. But in this situation, I think there is a special circumstance here. He does have a First Amendment right to talk about the case, and he will once that gag order is lifted. You could bet on that. But I don't think that there's a ton of harm in him waiting another month, going through the entire process of the sentencing, and then being able to speak about it freely with whoever he wants and however long he wants.
Doug, talk to us about the nature of a gag order. Is it typical for a gag order to be carried even after a conviction is found, even after a verdict is found, all the way until a sentencing date?
No, as Shondell correctly noted, there are two completely separate discussions. One is the validity of having entered a gag order. That was controversial, but the court upheld it. That's fine. But the second separate issue is maintaining a gag order when the trial's over. That makes no sense. And to your specific question, Sean, it's unusual. Gag orders are so that pretrial publicity won't infect the situation. Pre-trial, the trial's now over, and there's no need to maintain it, in my view, legally.
Shondell Summer, Aaron Reed, Doug Burns, thank you very much. We appreciate it. Great conversation.